Good afternoon. Thanks everyone for joining us for Advanced Strategies for Workplace Investigations, which Cherie Silberman is presenting for us today. The course number should be on the materials that you received, but as a reminder, it is 9479. Again, the course number is 9479. And as a heads up, you will receive the PowerPoint materials that Cherie's going over today sometime this week. So you get PowerPoint materials, and again, the course number is 9479. We'll leave a few minutes at the end for question and answer. And with that, we'll get started. So Cherie Silberman has been practicing law for 20 years. She received her undergraduate degree from University of Florida with high honors, and she received her JD from the University of Miami. She has significant experience helping companies with employment policies and practices. She's worked with a wide variety of companies, including some of the largest global companies, all the way down to family-owned and startup businesses. She focuses her practice on impartial workplace investigations and providing training to HR professionals and other employees on a wide variety of employment-related matters. She is an active member of the Association for Workplace Investigations and has received her AWI-CH credentials for completing the specific accredited workplace investigation training put on by AWI. Thank you so much, Cherie, and I'll turn it over to you.
Thank you, Alicia. I appreciate it. I'm excited to be here today because I love talking about workplace investigations. It's predominantly what I do now. I was a litigator for 15 years on the management side, and I decided that litigation was no longer for me. So 5 years ago, I started my own practice so that I could focus on conducting workplace investigations. And I got involved with the Association of Workplace Investigators and completed that institute that Alicia mentioned. So having the litigation background was been invaluable experience, but looking at investigations from a different approach and from a different lens has been a little eye-opening, and I wanted to share some insights on some areas that I think are investigators or anyone who's doing workplace investigations can benefit on. So we're going to touch upon some of that today. This is not intended to be an investigations, one-on-one course, basics. This is really just designed to dive into some of the emerging trends and challenges that I see in doing this work. So some of the areas that we will talk about today will include AI, because you can't talk about any topic today without discussing the implications of AI. So we'll talk about how that impacts workplace investigations and things that we need to keep in mind, particularly as attorneys. We're going to go over some of the credibility factors and best practices for assessing credibility, because it's really an important part of the work that we do as investigators to reach findings. When a client is hiring you or you are conducting an investigation for your own organization, you really don't want to be in a position where you can't reach a determination because it's a close call. And that's where some of these credibility factors really come into play. We're also going to talk about some laws and rules that are impacted with workplace investigations when you have witnesses that are in another state, and perhaps even in another country, because with remote work being so prevalent in many workplaces, there are going to be situations where you have issues that happen elsewhere or you have witnesses that are elsewhere. And so some things that we need to think about in those scenarios. And then I'll also talk about the attorney-client privilege and some considerations that you need to think about for ensuring that you're properly protecting the attorney-client privilege when you're doing this work. And a lot of this, will all apply whether you're doing an investigation in-house for your own organization or you're an external attorney that's doing an investigation for a company. So all of these things will come into play. So we're going to jump into AI. Obviously, AI is a rapidly evolving area, but it's not brand new. It's been around a bit, and I'm sure many or most of you are using some sort of AI in the work that you do already. So there are various ways that this shows up already embedded in some of the products you're probably using, like Zoom, Adobe, different web browsers. Sometimes you may realize that it's embedded in a program because you haven't opted out or you just clicked on the button, which sometimes we tend to do in order to use a product and don't realize what's happening in the background. So obviously we can't ignore it. Our clients are certainly not ignoring it. How many times have you had a situation where you've got a client that's calling you and they have all of this knowledge because Chat GPT has given them the answer that they want, and it's not necessarily the answer that you're giving them. So it's something that we have to become familiar with in all aspects of the work that we do. There are some AI programs that are specifically designed for workplace investigations, but whether you use those or you're using some other service, a lot of them have the same capabilities of doing things that can help in conducting a workplace investigation. And oftentimes, frankly, some of the work that you would otherwise be delegating to legal support or paralegal or someone who's billing at a lower hourly rate. So it's not perfect, and we'll talk about that. But some of the ways that investigators are using AI is to upload, you can upload your documents and it can create within a matter of seconds witness list, timelines and chronologies. They can also develop interview questions or at least give you some areas where you should think about considering asking certain questions for certain witnesses. There's this whole workflow automation process that can happen depending on which program you use. So let's say you can identify certain witnesses, and then it will look at the documents that you've uploaded. It can use OCR to read images and cut down on the hours of work that you would otherwise be searching to say, well, I know that this witness or some witness said something about this, but I can't find it. It will just automate that work for you. Again, not perfect, but quickly find in some documents where you might have an issue or a fact that was cited by a witness. Some of the programs actually provide source documents too. So once you upload your documents, it will index them. And then when it gives you questions or it identifies, yes, these people said something that had to do with this topic, it will give you a link to that document so you can check it pretty quickly yourself. It can analyze and highlight contradicting evidence that witnesses gave, and also it can do some drafting. I haven't seen any product that is great at this yet, where you can just click a button and generate an entire report. But it does have, a lot of these programs do have programs or at least features where you can write sections of a report and at least get you started with that hardest part. Some obviously issues that we need to consider that you're probably already considering in some of the other legal work that you're doing is, accuracy and reliability. Um, there are hallucinations that happen with obviously producing case law, but that happens in this type of work as well. So the results of your AI, it's only going to be as good as the data that you upload and the algorithms behind them. So again, even when it cites some sources, it doesn't always get it right. This is not a perfect system. So you always need to corroborate what the AI is giving you with your independent judgment. There's also bias, which is a potential concern. So AI may reflect or amplify some bias in your findings or in some of the analysis that it's doing. Even if the training and the programming is solid behind it, there are some ways that perhaps witnesses express information that could be interpreted in multiple different ways. So inherently, even if there's a well-developed program, you've got to be mindful of the fact that there could be some bias embedded in it and interpret it in a different way that a human would interpret it. You obviously have to be worried about confidentiality and data security. And this is a big one. Obviously, I think a lot of people are familiar with this, but you have to verify how the AI platform that you're using handles the data, stores the data, and whether it is in a secure site. And there are issues with how these tools may implicate confidentiality as well as data privacy. So with workplace investigations, they're obviously very sensitive situations, confidential proprietary information that we have for our clients or for the companies that we work for. And we need to be mindful of any AI product that we're using to make sure we're not inadvertently waiving attorney-client privilege or sharing confidential or sensitive information outside a secure space. Transparency and explainability is also an issue too. So if AI influences findings or investigative conclusions, you want to be prepared to answer the questions for that. If you end up having to defend an investigation and answering what did the AI tool do? How did you use it? Did you fact check it? What are the limitations? Again, a lot of questions regarding the security of the program that you're using. So, having the lack of transparency can really undermine the credibility and defensibility of the investigation that you're doing. So you want to make sure that you're being mindful of that and that you're getting proper consent for any program that you're using. And we'll talk about that a little bit more later in the presentation. There's also ethical and professional implications here. So, attorneys cannot delegate any judgment or professional judgment and decisions to the use of AI. You can use it as a tool, just as you would with an associate or a paraprofessional, but you cannot delegate your professional responsibility to it. So it's key to maintain oversight, accountability, and making sure that you're adhering to the rules of professional responsibility, which we'll talk about now. So, on the topic of confidentiality, there was a Florida Bar Ethics opinion that was issued almost 2 years ago, January of 2024, that talks about confidentiality. So it's Rule 24-1. And essentially, what it says is that a lawyer must protect the confidentiality of the client's information as required by other rules of the Florida Bar. And when it comes to AI, it's recommended that a lawyer obtain the informed consent of the client before using any third-party generative AI program, if using that program would potentially involve the disclosure of any confidential information. One part of this is that attorneys that are using AI have to understand the technology to satisfy their ethical obligations. So, as complicated as this may be, we really have to have a better understanding of what it is, not just to comply with the Florida Bar rules, but to make sure that we can explain it to our clients or to our stakeholders. Now, for generative AI, you have to understand whether the program that you're using is self-learning and whether it's something that is sharing the information that you're uploading to it to train itself, or whether it's kind of a closed system. And the bar rule actually specifically says that, attorneys need to have knowledge of whether the program is self-learning, and whether the client's information may be stored within the program and revealed in a response to a future inquiry by a third party. What you don't want to do is share information that can then be shared with the system and then generated in a response to a third party. Obviously, that's a huge concern with confidentiality and privilege. There's a difference between using a consumer version of a program versus an enterprise version of a program. And these are just things that you need to think about when you're vetting the programs that you're using. So ensure that the AI vendor that you're using has an obligation to preserve the confidentiality and security of the information. You want to do your due diligence to investigate the provider's reputation, look at their security measures and policies. There are specific tools, as I mentioned, AI products for workplace investigations. And a lot of the reputable ones are pretty transparent in their data security protocols. So they will have a dedicated portion of their website that talks about that shares the results of their security audits. Obviously, you want to look and see if they're SOC 2 compliant. I'm not necessarily saying that is a requirement in order to comply with the Florida bar rules, but those are things that you really want to have on your checklist to see if you're complying with your obligations to maintain confidentiality. So look to see, what the program is doing with your information while you're using it, and then when you're done using it, when you discontinue your services, is that information out there or is it only belong to you? So those are the things you need to be looking at. In terms of oversight, I mentioned this a little bit before, but you have to look at this as a tool. So you have to review the work product that AI is giving you in situations that are similar to reviewing the work that you would for legal support or other, non-attorney assistance. Ultimately, as the attorney, you are the one who is responsible for the data that you put out there in the work product. As in terms as in terms of the confidentiality requirements. You've all seen all of the headlines of all of the law firms and attorneys that have been hit with tens of thousands of dollars of sanctions, suspension of their bar license because they are uploading or providing cases and briefs to courts with complete hallucinations, cases that don't exist or don't say what it is that they're purporting to say. So the fact that this is still happening is concerning because we've heard about this for a couple of years now. But, the bottom line is to be mindful that this happens with workplace investigations as well. So it's not just when you're writing legal briefs. It's something that you need to keep in mind. There's another provision for this Florida bar ethics rule that we need to keep in mind that is also applicable to workplace investigations, at least for those of us who do this work as external counsel, and that is with legal fees and costs. So the rule says that you cannot charge for time that you spend learning a program, and you cannot overcharge for time that now you're being more efficient, but it would have taken you 4 hours, so you're going to bill 4 hours. That's something that's specifically prohibited by this rule. You can't also charge for the overhead of using these products. So when you're charging a client, you're going to charge for the time that you actually work, and you're not going to embed those in overhead costs. That's just a matter of being fair to the client and being transparent. So there's another part of 24-1 that talks about the use of AI that has to do with lawyer advertising, which I don't think comes into play so much with workplace investigations. So I'm not going to talk about that, but just kind of there is a bullet point there under that ethics rule regarding lawyer advertising. The EOC guidance, so I will say we could talk, probably for a whole hour about the EOC guidance and how EOC guidance has changed and all the flip-flops with the EOC. But there used to be in the previous guidance a discussion about AI. And earlier this year, both the Department of Labor and the EOC withdrew their guidance on AI and the impact and workplace discrimination and how that would impact workplace investigations. But I feel like it's worthy of saying that in general, the EOC has discouraged the just deferring to the use of AI in employment decisions and hiring decisions and certainly in disciplinary decisions. And that's where it could come into play with a workplace investigation. So if you were using an AI tool to make a decision and you don't have that element of attorney judgment and oversight, then you could be running afoul of some of the EOC guidance, or at least the previous EOC guidance, and we'll see how that shifts. But in other words, even though the guidance doesn't exist as the way it does, it's still a good practice. And I still think these are things that you need to keep in mind to make sure that you're complying with the Florida bar rules. So talking a little bit more about AI and investigations. As investigators, we are not the only ones using AI or potentially using AI. Our witnesses are using it. So let's say you're doing an investigation and you're trying to have witnesses describe the person who was present during an incident. They don't know the name of the person, but they're giving you some physical characteristics. So let's say there's a dispute about this woman's hairstyle, the length, whether it's straight, whether it's curly. You get this picture, you're focusing on this headshot of this individual, and the witness says, yeah, this is definitely the individual who was there. And you're focused on maybe the top half of the picture. How long did it take you to look at this picture and realize that there are some extra limbs in on this person's body? Maybe there's an extra hand there or some blurriness in the photo if you take a look at it. We're all trained to look at emails, spoof emails by identifying typos in it or getting information that's too good to be true, like, oh, you're a family member and, all of a sudden we have $1 million for you. All you have to do is click on this link. We learned about that probably 10, 15, maybe, years ago or more. So we've got that down, but now we have to do the same thing and conduct the same analysis for AI generated photos and other images. So some of the things that you would be looking at, obviously the visual cues. Don't focus on the one area. So in this example that I tried to give you, I was trying to have you focus on the top half of the picture. Maybe you didn't identify, depending how big your screen is, you could see it or not, that there's a little bit of blurriness in the jacket. That could just be Photoshop, right? It doesn't necessarily mean that it's AI generated. But once you start to look below, something looks a little off. So, look around, see if that, looks like a genuine or authentic picture. You also question the witness directly about this. Where did you get this picture? Was this text generated by AI, or a different computer program? Maybe the witness that's sharing it with you assumes that it was genuine and it's not. Um, Maybe this is an actual person, but they used AI to enhance it. I know a lot of people are taking their headshots and just using AI to enhance it in certain ways. Sometimes it adds another finger, like this did, but maybe it is completely AI generated and this is not an individual. So those are some of the things that you can start to look at and think about. Compare and cross-reference images with others. So I get a lot of images of text messages when I'm doing workplace investigations, and sometimes you can't tell on its face. It's very easy to create a fake text message. But if you're looking at a group of text messages, maybe the timestamp doesn't match up, or maybe the name of the sender is saved a little differently. There may be an explanation for it, such as sometimes, you'll see something that has a dark screen or a white background. And it may just be because, oh, my phone changes to nighttime mode at night. And yes, this is my same phone. Maybe there's an explanation for it, but those are things that you need to probe into. What about language consistency? So if we're talking about text messages or generated conversations, is this a way that someone would normally talk? Do they typically text with acronyms or are they using proper grammar? I know that, a lot of I have college students that pick my kids up from school and they text very differently than other people in my life. They're texting shorthand, and sometimes I may have to double check and make sure I understand what they're talking about. But I know that that's the way that they communicate. So if they started to communicate differently, I might question, is this really the person who's sending the message? And to be fair, I'm not stereotyping 20-year-olds, because I will tell you, when my teenage daughter sends me emails, she signs off with the word sincerely, and she writes her full name. And maybe that's just because she's new to sending emails, and so she'll get a little bit more abbreviated when she gets a little bit older. But again, I laughed, the first few times I saw it, and now I know that's just the way that she signs her emails. And so if she's saying that, it might come across differently to me than the 20-year-old college student that's picking her up who is just texting me in letters that I'm trying to decipher. So again, just look at the context of it and compare. In some cases, you may want to consider using an AI tool to detect an AI tool. This probably is overboard in some of the investigations that you do, but it's just another key and another tool to keep in mind depending on your scenario. And then, of course, it should go without saying, is to consider the weight of the evidence. So use the same judgment that you would in evaluating any other evidence that you would, that's not potentially AI generated. And so that goes into the topic of credibility. This is not a one slide fixes all problems telling you there's an AI program that can shortcut the credibility analysis, although I am aware of at least one AI program that is designed to be a deception detection tool. I'm not familiar with it. I've read about it, but that's not what we're using today. So, and also polygraphs is another thing, is rarely used in workplace investigations due to the Employee Polygraph Protection Act and things that we just don't want employees to undergo anyway. So there is no shortcut to that, which I guess is good news and bad news because we still have to use our brains to do the hard work. So let's talk a little bit about credibility assessments. I'm going to review 10 elements to evaluating credibility. And I'm going to be focusing on the AWI guidelines. Again, that's the Association of Workplace Investigators. They have guiding principles that were heavily influenced and drawn upon the previous EEOC guidance. That guidance was removed in 2024. And the current EOC guidance does talk about having someone who is well trained in the skills required for interviewing witnesses and evaluating credibility. So it's still part of the EOC guidance to do a credibility assessment. They just don't have these factors laid out as they used to. So it's still best practice or best standard practice to use these factors, but you're not going to find them identified in the current guidelines. So the first one I'm going to talk about is corroboration. And this is really a great standard to use when you've got witnesses saying something and then you have tangible information or documents to back it up. You could have corroboration from multiple witnesses. So you have a witness statement that's corroborated by individuals, other individuals who were there, who saw it, who had the same firsthand experience. Sometimes corroboration can come in the form of a contemporaneous reporting or recording. So I see this sometimes where an incident allegedly happens and someone involved sends a text message to someone else or calls someone else or emails someone else shortly thereafter. And that can be pretty useful in weighing credibility. There could be witness statements from someone who was not present for the incident, but they observed similar incidents with one of the parties, or they observed one of the individuals that was involved immediately after the fact. So let's say something happens, one individual is pretty upset, you have a witness who didn't see the interaction firsthand, but they saw the secondhand interaction. So those are all good examples of solid corroborating evidence. The next is opportunity and capacity to observe. So I often talk to people and they're giving me facts as if it's facts, but then when we back up and we ask questions about, well, did you see it firsthand? Did you hear it? Were you paying attention? Were you distracted? Where were you? Where were you facing? Were you close enough to hear the interaction? If it's someone who normally wears glasses and they weren't wearing glasses, those are all questions that you might look into when you're looking at the opportunity and capacity to observe. Consistent or inconsistent statements. So oftentimes you're going to be interviewing a witness and they may say something that changes a little bit afterwards. So allow them the opportunity to explain what might be an inconsistency. And keep in mind that memory can be influenced by many different factors. Just because someone's saying something and then it comes across differently or they say a little bit differently another time doesn't necessarily mean that they're lying. Memories can change over time, or there may be some sort of nuance that you didn't pick up on as to why they're saying it differently. So you need to probe into that. Past history is something. So let's say you've got a prior substantiated finding of similar behavior. That could be something that would weigh into the credibility assessment. Yeah, maybe you have an individual who has a history of making malicious complaints or unfounded complaints. That is something that you could take into consideration when you're weighing credibility. But be aware of bias too. So just because someone has made a complaint in the past that didn't turn out to be substantiated that doesn't necessarily mean that the current complaint that you're investigating doesn't have a lot of credibility to it. So just be mindful of that. And then plausibility is another one. So does this logically make sense? What programs or what someone, um, let's say someone is alleging that they received an email with salacious content, and the person said, I didn't mean to send it to you. I meant to send it to my significant other. And they have the same initials. So the email would have started with the same two letters. That seems like something that's plausible. Not to say they should or should not send the email, but that's an explanation that actually is plausible. Let's say someone says they heard something or heard a certain word, um, but there's someone else who said, no, I definitely didn't hear it. Did the person who say they didn't hear it have a hearing impairment? And that could explain the reason why this person is saying they didn't hear it, but everyone else in the room said they heard it. So those are just some examples of how plausibility could come into play. Bias is another. So bias could be for or against a particular fact. It could be bias in favor of a particular outcome. You want to look into and consider, are there financial or personal interests? Is someone who you're interviewing friends with or a family member of someone who's a party to the investigation? So would they have a bias? And not that's different than motive to lie, which we'll talk about, but it could be that they just have favorable opinion of this person. Maybe it's a manager who's always given them a raise, always given them a promotion, and so they think this person can do no wrong, and so they may say something that says, I've never seen this, I've never experienced this, there's no way this person would ever do it. There could be a bias coming into play there. So motive to lie, similar but different. So obviously, if you're in a situation where there's a respondent who's being accused of misconduct, they're always going to have a motivation to lie. They don't want to be disciplined. They don't want their reputation to be damaged. Not everyone who has a motive to lie will do so, but those are things that you need to take into consideration when you're looking at the evidence and it's a close call. So examine the relationships, understand the context. Someone who is reluctant and afraid, that what they say will come out combined with someone who is saying something that's favorable to another party. Those are all things that you need to think about, particularly when you have multiple witnesses who are saying things that might be slightly inconsistent. And so trying to figure out what could be the reason for that. Reputation for veracity or deceit. So it's for telling the truth or for not telling the truth. So if there's significant evidence that someone's been dishonest or deceitful, their reliability or significance of evidence may be greater. You may have a situation who there's a witness who they're known to just exaggerate everything. Again, doesn't mean that they're lying, but the way they perceive things is differently than maybe most other people. So, considering the source, considering the reliability and their reputation, it could be a factor that you consider. Again, you want to use this with caution. Just because someone has done something in the past doesn't necessarily mean that that's the case here. But, consider the similarity to the situation and whether that might be something that kind of pushes you over the edge when you're weighing credibility. The manner of responding to questions. So this is different than demeanor. But let's say there's a change in the manner of someone responding. They answer everything, they're confident about everything, and then all of a sudden they're giving you evasive answers. One kind of rule of thumb that I sometimes employ is kind of this 3-strike rule, right? If someone's not giving you an answer, they're not giving you a yes or no when you're asking yes or no questions. Did you see Pat touch Alex? And the person says, I stay away from the drama. Okay, have you ever seen Pat touch Alex? Oh, I see a lot of things. Okay. Are you able to say with certainty yes or no, whether you've ever seen Pat touch Alex on the back? Did someone say I did? Okay, in my mind, that seems to be trending in a way that the person is being evasive. So, sometimes I might outright say, are you going to answer the question? Again, I'm not trying to be combative at all. But if you get to an area where someone has been pretty communicative, responsive, and all of a sudden they're changing their tone on something that is of particular importance, that might be something that comes into play with your credibility assessment. And then finally, demeanor, and like I said, I use this with caution, is we are not human lie detectors. So just because someone is not looking us in the eye, especially when we're doing these on, virtual platforms, it doesn't necessarily mean that someone is not telling the truth. It may be that the witness is nervous. It may be that the witness is neurodivergent. It may be that they've experienced trauma in connection with the subject matter that you're talking to them about. It could be a cultural difference. So it's something that you could consider depending on the situation. But again, use it with caution. And it is disfavored, I will say, by AWI when they go over the guiding principles. But it is a factor there that could be helpful depending on the circumstance. Just a few other tips. The use of silence can be really helpful. Being interviewed can be really nerve-wracking. So, asking open-ended questions and pausing. I have gotten a 12-minute response in response to a non-question. And after literally 12 minutes, the individual said, and I don't know why, I just let the person keep talking. So what was the question? I said there really wasn't one, but that's okay. That doesn't happen all the time, but sometimes it can be a useful tool. If an employee starts saying something that contradicts what they said previously, go back, revisit it, but do it respectfully. Don't take the approach that you would if you're doing a cross-examination of a witness or a hostile witness. Say, you just want to make sure that your understanding is clear and that you've gotten it right, and you may have misunderstood something, so you just wanted to go back and get better clarity on that. If you're trying to drill down on specific events, there's a technique where you can kind of go backwards instead of going chronologically. I think a lot of times we ask questions when we're doing interviews, and certainly witnesses will share things chronologically, and that's appropriate. But sometimes, depending on what you're trying to get information on, if there are gaps, you can try a different technique, which is to go backwards. And I would explain it to the witness why you're doing that. That you're not trying to trick them, but just say, sometimes when we do this, it helps people remember things differently. So I just want to try something with you. And then go back and just say, what was the last thing that you saw Pat do before Alex walked out of the break room? And then hopefully you get a response. And then can you remember what happened right before that? Sometimes that might fill in the gaps. And you can look at this. You can look for red flags. Does the story fall apart? Are there new contradictions? Are there new pieces of information that you can then dive into? Sometimes it's really telling when there are rehearsed phrases that people are, they're coming into investigation, they're prepared to tell you something. But then when you go backwards, it kind of falls apart. So that's something. But again, be mindful. There may be a situation where there's a trauma impacted witness. So it may not be the best approach in that situation, but something to consider. And then looking at focused and diagnostic questioning. So when you discover an inconsistency, target in on some of the more focused questions. And that's when you're going to narrow in your line of questioning. So, but sometimes it's a close call. You have to, hone in on these credibility factors. What you need to remember as an attorney who's doing investigations or overseeing investigations is you are not the judge, and this is not a court of law. So something that might be considered inadmissible hearsay in court doesn't mean that you cannot listen to it and consider it. So don't exclude that information. And sometimes witnesses will self-identify. They're like, well, I don't know, it's hearsay. Okay, well, let's share the information that you have. You still have to weigh the evidence, and you want to track down the source of the evidence. Sometimes you won't be able to, but it doesn't mean that you have to exclude that information, especially if you have corroborating evidence. So just be mindful of that. Emails, obviously, if you are working for the company, if you're external counsel for the company, you can get company emails, but sometimes people are using their personal emails. So they might have access to something that you wouldn't have access to. Text messages and other messaging such as Slack, Zoom chat, Teams meetings, looking at deleted messages and emails. Also, when you've got a case where you have text messages involved. If you can, look at the devices, look at it from multiple devices and see if they are matched. Sometimes it's really interesting when I get a text thread from one party and it's very clear that it's very one-sided. Sometimes I can assume, other times I actually have something to match it up with. Conversations with confidants is something that can be really useful because if something happened that was especially upsetting to one of the parties, did they speak to someone about it? Did they speak to a family member about it or a friend about it? And sometimes just even asking these questions might jog a memory of other evidence or witnesses. I had this turned out to be helpful in a case where there was someone who said, "Oh yeah, I wrote a diary. Oh, and that reminds me, I texted my coworker, and this coworker hadn't been identified as a witness before, and that opened up a whole area of other evidence." So, just to give you a few other ideas of areas when you're struggling with, it's just one word versus the other, because that's not a situation you want to be in when you're conducting an investigation where you just say, well, I can't reach any findings, is to really dig into the evidence and looking at other pieces that you may not think of right away that you don't think are relevant to the case, whether it's call logs, voicemails, voice memos. People live and die by their phones, and so they use them in different ways. They're creating notes in an Apple notes. They're making calendar entries. They're downloading apps. Have they downloaded an app to use secure messaging because they're engaging in conversations that they wouldn't want someone else to know about? What about browsing history, building badge and swipes? Like those are all examples of things that have been helpful in cases that I've been involved in. All right, so I want to talk to the issue of investigating when you may have a witness or you may have situations outside of Florida. So, workplace investigations are typically conducted by an attorney, either in-house or external counsel or HR professionals. And many employers are not aware that there are some licensure requirements for those who do workplace investigations or investigations, not just in Florida, but in other states. So, if as an external attorney investigator, you're asked to conduct an investigation for employees in another state, I suggest you look into whether there are any laws in that state that might prohibit or restrict you from doing so. If you have a case that's here in Florida or witnesses are here in Florida, that's great. You're licensed. We're going to talk about that. But if you're a Florida attorney, external attorney, and you're asked to conduct a workplace investigation in California, everything took place in California, all the witnesses are in California, that's going to be a problem. So I'm going to tell you that there are multiple states that have laws like this, but I'm going to talk to you obviously about Florida's, which is the Private Investigative, Private Security and Repossession Services Act. And basically what this says is it requires any person who's conducting an investigation for the purpose of obtaining information with reference to specific matters, be a private licensed investigator under the statute. And then it defines what's considered a private investigation. And a lot of that has to do with looking at credibility of witnesses, looking at recovery of lost or stolen property, looking at the identity, habits, conducts, movements, things that I think a lot of the workplace investigations will look into. It says you have to be a licensed private investigator. However, it's okay, we're all safe. It includes a number of statutory exemptions from this requirement, including any attorney in the regular practice of his or her profession. So, as a licensed attorney conducting a workplace investigation, you are complying with this Florida statute that says you have to be a licensed private investigator to conduct a private investigation. But I will tell you that there are penalties for failing to comply with this. They range from monetary penalties. They can investigate and put penalties on your license, issue a reprimand, deny the application of a license, suspend your license, things like that, that obviously can be really impactful to continuing to perform this work at all. So just be mindful of this. I will say there's not a lot of authority on this when it comes to conducting workplace investigations, specifically in Florida, which may be why many of you have never heard of this. However, there's a lot in California. California has a similar law, as do many other states. And so looking at how this has been interpreted in California can kind of inform the way that it might be if all of a sudden there's a challenge and someone wants to say that an HR professional is not properly licensed to do a workplace investigation. So if you have clients that are utilizing HR resources to conduct, and not internal HR, but external HR companies to do an investigation without, especially if they're doing this without an attorney involved, I would just caution you to maybe look into this to make sure that there are no issues for failing to comply with this. And then we'll talk about the attorney-client privilege as well. Some other areas where conducting investigations across state lines could be an issue is when you have employees in another state or witnesses in another state. They have different recording laws. Obviously, Florida is a two-party consent state, so you need to make sure that if you're doing any recording or you obtain any recording, that you have proper consent. But again, that's going to vary across state lines. There are also differences in different countries where maybe you have a witness who's in the UK and they have the right to representation during an interview. So those are things that you need to think through depending on where your witnesses are located. And not just different laws and regulations, but different countries have different norms in terms of what's expected regarding notice and whether you're recording and whether you're providing a copy of interview notes. So just plan ahead, be mindful of, the particular licensure requirements, especially when you have a situation where there are a lot of witnesses in another state. If you have someone who does not speak your native language, make sure that you plan for the use of a translator, that it's someone who shouldn't be a witness that is involved in the matter. Evaluate cultural differences that could come into play that might impact how you plan and organize. And then, of course, the licensure requirements, as I mentioned. And then the last topic we're going to talk about, because I want to make sure that we leave time for Q&A, is safeguarding the attorney-client privilege. So this is another reason to consider who is conducting the investigation. We're all Florida Bar attorneys, so we have that checked. But if you have a client who's considering having an investigation done by a human resources professional, an external human resources professional without any legal direction, this could be a problem, a potential problem. When you're doing an independent investigation, as an attorney, you hold a unique role because you're being retained by the company, but you also need to be impartial and unbiased. So knowing the kind of the parameters of attorney-client privilege will kind of inform how you engage with the client if you're the external or if you're or with the internal or independent investigator if you're the one who's in-house, who's retaining an external. Obviously, just like with any other legal work we do, the privilege belongs to the client, belongs to the company. So often an employer will desire to maintain that privilege depending on what the findings show. But there may be situations where the company wants to waive that privilege to show that they did the right thing. They conducted a prompt and thorough investigation. They made some decisions based on the findings that were included in that investigation report. But when that happens, be mindful that if you're waiving the privilege for that investigation file, it's waiving the entire privilege for the entire investigation file. So you don't want to be in a situation where you have the independent investigator who's also functioning as the advising attorney, because you may not, if you're waiving the investigation privilege, you don't want to waive it for the legal advice that you're getting. And that's one of the benefits of having an external investigator, attorney investigator involved, because you can really bifurcate the roles, working together, but making it really clean if the client's in a situation where they want to waive the privilege. So as I mentioned, there's a benefit of doing this work as an attorney, not just the attorney-client privilege, but then being compliant with that Florida statute on conducting investigations. But because we're functioning as an attorney, the ethics rules apply, right? So like Florida Bar Rule 4-4.2 You know, we need to make sure if we are communicating with a represented individual that the client, that the individual's attorney is giving us consent to speak to them. We cannot communicate with a represented party if we're talking about a subject matter that they have counsel on, unless that counsel gives consent. We also have to be mindful of giving an upjohn warning. So when you're talking to witnesses, it's important that you provide employees with an understanding of who you are, what the role you're doing. Make it clear you do not represent them. You're engaged by the company, or if you're internal counsel, that you are counsel for the company. There's an attorney-client privilege that exists, but it belongs to the company. They cannot divulge information. But make it clear you're here in a capacity as an independent. You don't have any predetermined outcome, but you don't represent them. It's that's basically the bottom line for the upjohn warning, because a lot of individuals can be a little confused about, well, you're an attorney, who do you represent? So it's really important to give that. As attorneys, we have a duty not to deceive. So, when we need to make sure that we're not pretending like we have another witness in another room who's going to say something against them, and avoiding conflict of interest. And finally, establishing clarity regarding the attorney's role. So if you're in-house counsel, you got to be functioning as an attorney, not just in a business capacity. If you're external counsel, you want to make sure that you're putting information in your engagement letter that specifies that you're providing, attorney services, but you are an independent. So just making sure that that's clear from the outset. And finally, this is my last slide, and then we'll have a few minutes for Q&A. Whenever I do an investigation, I kind of have this dual mindset, which is making sure that all safeguards are in place at the outset, in my engagement letter, in the admonitions that I give, when I'm planning with counsel, to maintain that privilege if the client decides that they want to have the attorney-client privilege protect the investigation. But at the same time, I'm anticipating that there is a potential that the client may waive the privilege in the future. So every email that I send, every communication that we have, I'm mindful of the fact that that could be disclosed if they waive the privilege. So just keep that in mind. Obviously, there are differences, public sector, private sector, in terms of what may be requested in a public records request for the public sector. You want to avoid inadvertent waivers. So again, making sure if you're an external attorney investigator, that you're staying within the scope of what you're doing, you're not providing the legal advice, and that their attorney that's providing the legal advice is the one who's doing that, so that if they waive the privilege, it's not waiving that part. And then if you're not sure, consult, counsel that's acting in an advisory capacity. You're not the one who's going to be giving the legal advice to the client. So I may have been 4 minutes over my goal, but I think we have enough time for Q&A.
Thanks, Cherie. That was wonderful, very helpful. We have a handful of questions. So Gail Ferb asked, what AI programs should we consider using for investigations?
There are a lot out there. Two that I'm most familiar with for conducting workplace investigations are TensorCase and Calabria. I don't know if I can answer it in here. I can spell it. Tensor, Tensor case. And then Calabria is with a K, Kolabria, Calabria, Kolabrya. Then there's, Gemini. Sometimes when people are using, Google Docs, Gemini is kind of embedded in that. I know some people use that, although it's not necessarily specific for workplace investigators. But the two that I first mentioned are the ones that are specifically for workplace investigations. I'm not recommending anything, obviously, specifically. I've definitely played around with and starting to use, but those I know are the two that are specifically for workplace investigations.
Great. I can handle the second question, which is whether the slide deck will be available after the presentation. That will be emailed to you at some point during this week. So you should get the PowerPoint later this week. All right, the next question is, how much detail about credibility do you put in a written report? Are you going through all of the credibility factors, or maybe making a general statement as to whether a witness appeared credible or not credible?
Yeah, that's a great question. So number one, if I'm doing a comprehensive report as opposed to an abbreviated executive summary report that doesn't go into that, I'm definitely going to credibility for the witnesses where it makes sense. I don't go through all of the 10 factors for every single individual. Someone would not want to read that type of report, and some of them just don't apply. But especially where there's a close call, I am definitely going into the credibility analysis, and I'm making sure that I'm explaining both sides, that this person said this and I consider this. However, the weight of the evidence is stronger on this side because of plausibility, the corroboration, whatever the applicable credibility factors are in that case.
All right, next question. What procedure is better for scheduling witness interviews? The investigator makes the contact or the HR rep?
So it really is going to depend on the organization and what their policies and culture call for. So I've seen a variety of different things. Most often, what I do is once I have a plan with the client, usually the internal, whether it's counsel or HR professional, will either introduce us via email or let them know that, here's my contact information, they should reach out to me, or vice versa. Or if we're doing this in person, which does still happen, then obviously they'll make that introduction in person, not necessarily far in advance, but so I would say most often you're going to have an internal because you don't want a situation where they have no idea what's coming. And should I be talking to this person? So I would start there, and then depending on what your organization calls for, go from there.
When you give the upjohn warning, do you tell the witness they have the right to hire their own attorney? If they say they will hire their own attorney, how do you proceed?
Yeah, so I don't necessarily say that they have the right to hire their own attorney. And one of the reasons for that is there are a lot of organizations that have a policy about we don't let witnesses come with a representative or have anyone. Obviously, that's a game changer, though, when you have an attorney who's the one who's doing the investigation. So I don't necessarily come out right and say you have the right to hire your own attorney, especially if it's in a case where I'm not talking to the respondent and it's just a witness. Um, but if they ask, I certainly will answer the question, and I'm never going to tell them or give them legal advice to say you need an attorney or you don't need an attorney. I'm not going to be in that position. I do go into great lengths sometimes, it can be a lengthy discussion about my role, who I am. If they say they have an attorney or they need to get an attorney, I'm not going to be in a position to say, well, you have to talk to me. We're going to, terminate the conversation and go from there. But I don't necessarily say you have a right to an attorney because, especially if it's in a case where it's just a witness that doesn't warrant it, I don't want to make them think, I don't want to create problems for the client too, make them think that they're in a situation where they need one. It almost sounds like a Miranda warning, which is not the way we want it to come across.
Do you recommend contract attorney investigators form an LLC or PLLC?
I would consult with your tax professional. Yeah.
Okay,
Yeah, I think that's all I see, right?
those are all of the questions. So thank you again very much, Cherie. This was a fantastic and informative presentation. As a reminder, the course number is 9479. You will receive the materials later this week. And we, of course, have upcoming additional webinars and CLEs we'd like to ensure you're all aware of. The next webinar is 2 weeks from today, December 1st at noon. That is Understanding Retaliation under Florida's Private Whistleblower Act. And then in January 15th to 16th at Le Meridian in downtown Tampa, we will have the annual update and certification review. That's 2-day presentation, January 15th and 16th. So please mark your calendars for that. And as always, we appreciate your attendance today and your involvement in the section. And feel free to reach out to any of us if you have an interest in getting more involved in section activities. Thanks, Cherie.
Thank you, Alicia.
Thanks, Amy. Have a great